The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good afternoon, counsel, and welcome to the Fourth Circuit. Judge Quattlebaum, Judge Rushing, and I are pleased to be hearing argument first in the Bonnie Peltier versus Charter Day School, both the appeal and the cross appeal. Mr. Street, would you please proceed?
Thank you, Your Honor, and may it please the court, Aaron Street on behalf of Charter Day School, Inc. and the other defendants. The plaintiff's Equal Protection Clause and Title IX claims fail at the threshold without reaching the merits of the uniform policy. Their Equal Protection Clause claim fails because the defendants are not state actors. And their Title IX claim fails because a binding Department of Education regulation reasonably interprets Title IX to permit sex-specific dress codes. This court should decline plaintiff's invitation to be the first court of appeals to hold that a nonprofit charter school corporation is a state actor, and to be the first court of any level to strike down a comprehensive school dress code under Title IX. Turning to the Equal Protection Clause, whatever one thinks about the uniform policy, it is not the policy of the state of North Carolina. It was formulated by a private nonprofit corporation with a wholly private board, no state officials on the board. And it is undisputed that the state had no input whatsoever into the content of the uniform policy. Charter Day School, Inc. and the other defendants, therefore, are not state actors.
Hey, Mr. Street, if you could factor into your analysis, please, the fact that the North Carolina statute designates the school as a public school and CDS receives 95% of its funding from governmental sources. If you could make that part of your analysis, I think it would be helpful.
Certainly, Your Honor. And I think the first important thing to note there is that the North Carolina statute, in the same section that it designates the charter school to be a public school, specifically provides that the charter school will be operated and all of the policies will be formulated by a private nonprofit corporation. So the designation public doesn't make a functional difference here. And in fact, it just makes the case on all fours with the Ninth Circuit's Cavanis decision, which also involved a charter school that was labeled public, run by a private nonprofit corporation.
Okay, Mr. Street, if I could mention here, though, Cavanis and Rendell Baker both dealt with the situation of the employer-employee relationship. And there was no direct imposition on a child in the school of a particular policy, unlike what we have here. Does that make a difference?
No, Your Honor, it does not make a difference, because in both of those cases that Your Honor mentioned, the court asked the same two questions that apply here: whether the defendants are executing a traditionally exclusive state function, and whether the challenged policy has been compelled by some government regulation. The court asked that same question in Rendell Baker and Cavanis, even though those were employee cases. The questions dealt with the provision of education. And I would mention in the Lagio Dees case from the First Circuit, which we discussed extensively in our second brief, the plaintiffs in that case made the exact same argument that Your Honor referenced. They said this is in the Cavanis case, the plaintiffs made the exact same argument that Your Honor referenced. They said this is different, it's a student case, it's an employee case, not a student case. And the Supreme Court in the Ninth Circuit in that case said it didn't make a difference. And in the Lagio Dees case, that was a student case. That was a student discipline code case. And the First Circuit, in a very thoughtful opinion by Judge Boudin, said that it made no difference to the analysis. The question was still the same: whether the charter was carrying out a traditionally exclusive state function. And coming back to your question about...
Counsel, if I could jump in, this is Judge Quattlebaum. Do you contend that CDS and RBA are entitled to government immunity? And if so, how does that play into the state actor issue?
We do not contend that, Your Honor. We think that the Court of Appeals that has reached that holding in North Carolina has erred. And I think it's notable that the North Carolina Supreme Court has taken up that decision on review. But whatever way that decision comes out, that does not resolve the very different question of state actor status under federal law. Immunity under state law and state actor status under federal law ask very different questions. And if I could unpack that just for a minute, the question of immunity under state law is whether the state has outsourced or delegated some governmental function. The question for state actor status is whether they have outsourced a traditionally exclusive state function. I think everybody agrees education is not a traditionally exclusive state function. This court has held that, other circuits have held that, the Supreme Court has held that. But second, the immunity question under state law next asks the question of whether the state intended to delegate some level of its immunity to the private actor because by virtue of the fact that it's heavily regulating the government contractor. That's a different question, again, from state actor status under federal law, where the question is not whether there's some generic level of regulation. The question is whether the particular challenged action was compelled by some government regulation.
Okay. But Mr. Street, don't the cases say we look at the totality of the circumstances and that here the state has delegated part of its constitutional duty to provide a public compulsory education, has delegated that function to the charter school. And that's a traditionally exclusive function to provide compulsory education. So why isn't that state action?
Well, let me answer that in two parts, because I think you've touched on two themes of the plaintiff arguments. The first is that they rely very heavily on the concept of delegating a constitutional duty. But we know from Rendell Baker, and we know from Cavanis, and we know from Lagio that that is not the test for private contractors who are involved in the education service. And the reason is because probably all state constitutions say that providing education is a core constitutional function of the state. But nonetheless, in those cases, the courts did not ask whether there had been some constitutional duty delegated. The question was very different. It was whether a traditionally exclusive state function had been delegated. Now, I think that leads into my second part of it.
Yeah, let me ask you, though, if I could, and I don't mean to cut you off, but I want to focus on this. Is there a distinction that you're drawing here between CDS and RBA? Because RBA is the contractor, as you know, of CDS, and you seem to be, and I want to make sure I'm not, mischaracterizing your position, but you don't seem to be drawing a distinction between the two. Do you distinguish between the two? And is CDS not more in the state action end of the continuum than RBA?
Well, yes, Your Honor, we are drawing a distinction between them, but only to the extent that RBA is further removed from state action than CDS. Now, CDS is a contractor of the state of North Carolina, and RBA is a contractor of the state of North Carolina. So they're one step removed. But even CDS Inc. is just a contractor that has contracted to provide education. Now, getting back to your second part of your question, Your Honor, you said, well, isn't public education traditionally an exclusive function? And again, Your Honor, I think we have to look back to Cavanis, which involved a public school and rejected.
Yeah, but if let's just say for a minute that I don't accept your employer-employee construct, and that Cavanis, well, first of all, isn't binding anyway, but
sure.
That there is a distinction. What I want is charter schools, exist only by grace of the state. They're only there because the state lets them be there and delegates them as core function of public compulsory education. So how do you get away from that? I mean, I understand RBA completely, your argument on that, but how do you get away from that with CDS?
Well, Your Honor, I'm not just invoking Cavanis to
employee context.
Sure. And of course, I'm not just invoking Cavanis to suggest this court should blindly follow what the Ninth Circuit did. I'm suggesting that case correctly analyzes these questions. And even though in that case, the state had delegated its public function of providing public education, the court said this is a functional question under Supreme Court analysis. The question is not whether the label is public. The question is not whether the state has carved off some amount of its constitutional duty. If that were the case, Rendell Baker would have come out the other way. That was also publicly funded and open to individuals that the state had taken care of in the past. So we think the question is not one of labels, and if it were one of...
Go ahead and finish your answer, please. I'm sorry. I have a question when you do, but finish that. I apologize.
Sure, Your Honor. And my point was to just finish that answer is that the public label that is here in the statute on CDS does not tell us anything about the function that has been delegated. The function is educating children. That's not a traditionally exclusive function. And the public label also doesn't tell us anything about whether the state has regulated to compel this particular challenged action. And I'll loop back later, but I want to hear your question, Your Honor. I didn't mean to drone on that point.
So before you get past the exclusive traditional function issue, it seems to me important, how you describe the function that we're talking about. I mean, Rendell Baker, it seems like, said that education is not the exclusive traditional function. I think that much is pretty clear. But then it also talked about the nature of that school, students who had such problems that their adjustment situation was that they effectively couldn't be, taught in the traditional sense. And so I guess here in our case, do we look at it as, public free education, or do we look at it maybe more granularly as alternative educational options of public education, which is where charter schools, their place is. So I'm just trying to figure out what we're looking at. Is it education? Is it alternative methods of education? Or how do we look at that issue?
Sure. So I think, Your Honor, you look at the function of what is actually being provided. And the function of what is actually being provided in Rendell Baker, you're correct. That was a subset of essentially special needs children. Here, the function is providing secondary and primary education to all comers. This school is open to everybody. It's publicly funded. So the question is whether providing primary and secondary education is a historically exclusive government function. And I think Cavanis and Laggiodis correctly answer that question and say, no, of course, providing primary and secondary education to kids who are in the normal school population is not. We've had private schools, we've had homeschooling for time immemorial. But getting to the function question, Your Honor, I think I understand the gist of the questions about the public label here and that this is at least nominally part of the public education system, but I think it's important to drill down a bit into the statute and see what the legislature meant by that public label.
Okay,
First of all,
before you do that, though, something that's been bothering me since this began, and maybe you could help me with this. We're talking about gender here, and what if let's change the situation to race. And what if this charter school decided that it could put all of the African American students, make them sit in the back of the classroom in order to get their education? So they would be discriminating against these students based on their race, not on their gender. Are you saying there would be no state action because these children, because this charter school was allowing this racial discrimination, but it was a charter school and not a public school. See, that's what I'm having trouble on. It, you know, sometimes gender bias seems more benign in some respects to some people, but let's make it about race. Could a charter school put the Black students in the back of the class and be immune from any action because they are not a state actor?
Well, Your Honor, the state action question would be the same. But no, of course, a charter school could not do that because a charter school is governed by its charter with the state. And the state charter says that the charters have to comply with the federal and state constitutions, including the non-discrimination provisions. And that gets to a very important point, which is that these plaintiffs have options to try to enforce their rights here if they think this policy is discriminatory. They should go to the State Board of Education and say, we think CDS Inc. is violating its charter with the non-discrimination provisions. And the state could sue for a breach of contract. These plaintiffs also have a pending third-party beneficiary claim under the charter agreement. So they believe that they have some option here. But instead, they're coming into federal court and bringing a fee-shifting case against an entity that the state specifically took outside of the charter of the public school chain of command and said, quote, operates independently of the existing schools, is exempt from statutes related to the existing schools. And I see I'm out of time on my opening.
Okay, let's see if the other judges have questions before you sit down. Okay,
not for me.
Okay, Judge Rushing?
No thanks.
Okay, thank you. Ms. Sherwin.
Thank you, Your Honor. May it please the court, my name is Galen Sherwin for the plaintiff. Every day, in order to attend their public school, the plaintiffs had to put on a uniform that was designed to convey the message that girls and boys should be treated differently, and specifically, that girls should be treated more gently than boys. Now, although this case requires the application of Title IX and Equal Protection Clause in a novel context, specifically a public school uniform policy that requires girls to wear skirts, it is actually the defendant who is asking this court to break with long-standing legal principles and ignore the record. And that's true in at least three respects. First, they would have this court hold that the skirts requirement, a facially sex-based rule, is not subject to heightened scrutiny simply because it is contained in a dress code, and to uphold that rule, notwithstanding its stated purpose to instill traditional gender roles. Second, they asked the court to hold that Title IX, despite this statute's sweeping language and its intent to eradicate different treatment of boys and girls, contains an implied exception for sex-based dress codes like the CDS uniform. And third, they asked the court to hold that North Carolina's public charter schools are categorically outside the reach of the Constitution and therefore free to violate students' rights with far-reaching implications for the more than 100,000 students who attend those. I'd like to address each of these issues in turn.
Okay, Ms. Sherman, while you're doing that, it would be helpful for you to analyze this in the context of Rendell Baker and Cavanis. Mr. Street is placing, pretty significant reliance on that. And so why are those cases inapposite? If you'd make sure that's part of your presentation.
Certainly, Your Honor. The defendants are saying that that our analysis would have the court ignore the legislature's will and hinge on just one item, which is whether this is a public school. The defendants are actually hinging their analysis on the fact that this is a private corporation rather than a public corporation. The North Carolina legislature, when it established the charter school system, did not create a shadow public school system for the more than 100,000 students as a sort of a civil rights free zone. And on the contrary, the legislature was careful to specify that charter schools are required to comply with constitutional and civil rights requirements. Now, with respect to Rendell Baker, it is correct that as Your Honor pointed out, that school was not a school that was designated as a public school. It was a private school, and it was engaged in a narrow set of activities related to education and a narrow slice of the student population. It was not, like the charter schools in North Carolina, open to all comers and designated by law as a public school.
But council wasn't and I think that's a fair distinction and appreciate that. How do you deal with the fact that despite that, it received, I think, more, 99% versus 95% of its funding from the public, that it was students were referred from the public institutions and that the public school district, certified or did something, I may have that term a little bit off, with the diplomas. I think there's some factual differences there. But there's some things that are pretty similar, and I'm trying to. I didn't read Rendell Baker necessarily as making the points you're making the basis of its holding. So maybe I misread it. But how do you? There's some differences. There's some similarities. What would you say about that?
Your Honor, you're correct that there are some similarities, but the differences here are really determinative and principally, it is the designation of the school as a public institution, as a public school that's basically on the same footing as local public schools under North Carolina law when it comes to this question. In addition, it's the distinction that Judge Keenan pointed out, that this was not a case relating to the provision of education by students. It was an employment case, as was the Kavanaugh's case. And in Kavanaugh's, the court was careful to say that an entity may be a state actor for certain purposes and not for others. And in fact, later, the Ninth Circuit did go back in another case, in an unpublished decision. This is the Nampa Classical Academy versus Gosling opinion, and make that distinction that in that case, it did not concern the provision of public education to students. And the Nampa Academy case did. So the court is definitely in that case recognizing that it is a functional and fact-based analysis. And what the defense are asking this court to do is hinge its ruling entirely on the fact that this is a private corporation, or they're both private corporations. And that is not what this analysis requires. So, Your Honor, I could also just, to the Logiod's case in Maine, that case, the distinctions are, and that is the one case that the defendants cite that does concern education, provision of education and education policy. But the Maine statutory situation was entirely different. The history was entirely different. Maine had a long history of contracting out entire school district education to private schools. And that is not the case in North Carolina. In North Carolina, the history of providing of the state's first function of providing education, public free education to all comers, dates back to at least the 1860s. So, and there is not the same level of contracting that out. So here you have a different history, you have a different statutory scheme in play.
And Ms. Sherwin, when you look at Rendell Baker, the court seems to be emphasizing the private nature of the school. They talk about it as being akin to a government contractor. I don't know. They said that the private school is a lot like a government contractor that fulfills public infrastructure contracts. And I thought that wasn't really clear in terms of what we're looking at today. So how do you fit that kind of analogy into what we've got to decide today?
That's correct, Your Honor. I think that's an important distinction because the nature of the services that were being provided to the student population in Rendell Baker were very specialized. It was, again, a very narrow group of students that were being treated, could not be treated in the regular public school system as a whole. And therefore, the state entered into that contract with the school, with a private school, to provide those specialized services. That's, again, very different than the situation we are looking at here, where charter day school is defined as a public school. It is required to accept all comers, and it is situated within, essentially delegated, the authority that lies solely with the state, but has been delegated to the charter schools under Article 9, Section 2. that is otherwise the state's alone, as a matter of history in North Carolina and as a matter of the statutory scheme. So I think that
Council, if I could ask two questions, and that's probably unfair, but let me know if I get off, if I need to repeat anything. But the first one on the state actor, the same thing I asked your colleague, if you could address the extent to which the governmental immunity issue you believe plays into this. And then the second question I have is, I realize if the answer is yes, it doesn't mean you should lose here. But do you agree with your colleague that you have an avenue for prevailing under a constitutional theory other than a 1983 action, your third-party beneficiary claim? So those are the two questions. I'm sorry to hit you twice.
That's fine. I'll take, no problem, Your Honor. I will take the second one first. We do have a third-party beneficiary contract claim that is pending currently under a stay. And it's sort of a belt and suspenders approach. You're arguing those in the alternative. So that does not mean we cannot be here today before this court. I think well established that public schools.
Yeah, I'm not suggesting otherwise. Yeah.
Right. So on the question of immunity, the immunity analysis part, it has been taken into account in this court's cases, including in the Goldstein volunteer fire department case. That's certainly a factor. And the question that the High Court in North Carolina has taken up is really the question of whether the charter schools enjoy sovereign immunity at the same level as the state itself, or whether they enjoy the same level of governmental immunity that is enjoyed by a traditional public school. So no matter how the court answers that question, the state action analysis doesn't change. Essentially, the state has delegated its authority and its constitutional obligation to provide free public education. And with that, it has also conferred a certain amount of immunity. It basically placed the charter schools on exactly the same footing with respect to immunity as a traditional public school. And therefore,
I'm sorry, go ahead, please. I didn't mean to interrupt.
I was going to say that therefore, if the policy would violate the Constitution in a traditional public school, it would violate the Constitution at the charter school.
Okay, that's kind of where I was leading, because Mr. Street gave a kind of an unqualified answer to my race hypothetical. He said, well, you know, aside from the gender into the area of race and the kids being forced to sit in the back of the classroom, that would be a violation of the charter. So you couldn't discriminate on race. You can discriminate based on gender and make the girls wear skirts when the boys can't wear skirts, but you can't discriminate based on race. So could you answer that? How do you respond to that?
The charter is clear that the school cannot violate, has to comply with the Constitution and civil rights laws. That's one of the provisions of the charter, and that is actually specified in the charter schools law. So that Mr. Street is incorrect in stating that the charter allows for gender discrimination of the type that is in play in this case. And if I could just get to that point, the merits of the case here. The issue here is that the defendants are attempting to evade the application of heightened scrutiny. And once we have applied heightened scrutiny, it becomes very clear that this first requirement cannot stand. And that is because it is expressly premised on and intended to perpetuate sex role stereotypes that have been invalidated by the Supreme Court again and again. The court doesn't have to look far to see those stereotypes, although you wouldn't know it from reading the defendant's briefs, because the school officials, including the school's president, Baker Mitchell, came right out and said it. And those same justifications have been offered by school officials and embraced by the board of directors of CDS. So it's plain that the sole purpose of the skirts requirement, requiring girls to wear skirts, was to signal gender differences, to teach children that girls should be treated more gently than boys, and to perpetuate gender roles that have been struck down by the Supreme Court again and again and held invalid. So here it's understandable that they would attempt to evade the application of heightened scrutiny. what they are arguing, that there is some threshold showing that must be made in order to demonstrate, in order to trigger heightened scrutiny, that proposition finds no footing in equal protection. There is no such requirement of showing discrimination for the application of heightened scrutiny. And that's because heightened scrutiny is the tool that the courts use in order to determine whether a sex-based classification is discriminatory. So for that reason, this requirement absolutely has no valid justification. The other justifications that are offered are equally invalid. The notion that the fact that a majority of parents approve of the skirts requirement or the uniform policy as it stands, or that they wanted uniform policy that distinguished between boys and girls.
Well, I don't think anybody's contending in this case that parents can surrender the constitutional rights of their children. I don't think Mr. Street's making that case. He's just saying that the school isn't a state actor, so it is free to discriminate.
Your Honor, I did read their briefs as making that point, that children enjoy less constitutional rights than adults, and that is absolutely not true when it comes to discrimination. So, Your Honor, you're correct in saying that that would be a profound departure from bedrock principles of constitutional rights, right?
Could you address the Morales-Santana holding of the Supreme Court, in which the Supreme Court very recently said that all sex-based classifications are subject to heightened scrutiny?
Yes, Your Honor, that was exactly what the court held, and the court made plain that there are.
Here?
I'm sorry, I didn't hear that.
How does that play in here?
It makes plain that there are no categorical exceptions for dress codes or any other type of sex-based classification. As long as there is a sex-based classification, then the state has the obligation and the heavy burden of coming forward with an adequate justification that shows that the sex classification is substantially related to that purpose. And the charter school in this case has not done that, because the justifications they have offered sound in the same type of benign paternalism that the court has validated again and again.
Counsel, if assuming we are at the heightened protection analysis, and I'd like you to assume something I know you disagree with, that you look at the dress code as a whole as opposed to the specific aspect of it that your arguments are focused on. Would you, but assume we're talking about the dress code as a whole, would you still say that it fails the heightened scrutiny test, or would you say that it does not?
If you're looking at the dress code as a whole, it does, because of the overtly stereotype-based justifications that are being offered for it. And that applies really to the skirts requirement, regardless of any other effects that it may have on male students. And I see that my time is up.
Well, let me ask you one question based on what Judge Quattlebaum just asked. So your point is that we're not, and I'm trying to figure out if this is your point. Obviously, boys aren't wearing skirts here, and they can't wear skirts under the policy, right?
That's correct.
You're not allowed to wear skirts, even though wearing skirts instills discipline and respect and other things. It apparently only instills that, I guess, in boys when they look at girls, okay, allegedly. But it seems to me that when the Supreme Court was talking in Bostick, it was saying that discrimination against one gender doesn't excuse discrimination against another. And so what I'm asking you here is the fact that the boys are being discriminated against too, because they can't choose their clothing. They've got to wear khaki pants or shorts, and they have to wear their shirts. Your position, if I'm correct, then, is that doesn't excuse the discrimination against the girls. It isn't a wash. As the Supreme Court said in Bostick, Hannah and Bob are both being discriminated against. That's your position, right?
That is our position, Your Honor, that does not allow does not allow the charter day school to evade liability. And in fact, it would double their.
Okay. Let me see. I think I think we are now back to Mr. Street. Thank you. Mr. Street?
Thank you, Your Honor. And I'd like to circle back to some of the questions that the court just asked my colleague, as well as some of the initial questions, to try to really focus the argument here on what's at issue. First of all, I think it's very...
we need to talk about Title IX too.
Yes, and I'm happy to do that. Let me try to touch briefly on some of the state action questions and then turn to Title IX. So I think, first of all, it's very important to look at the Supreme Court's most recent word on state action, which is Manhattan Community versus Halleck. And there the Supreme Court said that the traditionally and exclusive state functions are, quote, sovereign functions. They are, quote, very few. In previous cases, the court has said that these are things like elections, eminent domain, criminal justice system. Education is not something that is in that category that's uniquely only done by the sovereign. Second, on the governmental immunity set of questions, again, I think we both agree, both myself and Ms. Sherwin agree that the answer to that question is not dispositive one way or the other. But I think it is important that there are courts that have found a private entity to be a government subdivision, but nonetheless not a state actor. We cite a Ninth Circuit case in our brief on that. And this court's case in Goldstein, which Ms. Sherwin referred to, is very illuminating on that point. There, the court looked at whether the private firefighting company was immune only as an additional factor after it had first determined that firefighting was a traditionally exclusive state activity at the time that the delegation had been made. And the court only reached the immunity question after it made that holding and that it observed that the private firefighting company had incidents of sovereignty like police power, the ability to literally break down the doors of unconsenting individuals. So we have obviously nothing like that here. Yes.
Counsel, I know you want to get to that, but I got some questions on Title IX, so I'm sorry to redirect you, but do you have obviously the district court applied Chevron deference to the department, the predecessor Department of Education's withdrawal of the appearance code or the appearance factor in the regulations. Is there I'm not really a withdrawal of a regulation as opposed to the statement of something else, something more affirmative. And I understand a case like this where the withdrawal has been afforded Chevron deference.
Your Honor, I'm not aware of a case that addresses that one way or the other. But the question is whether, of course, the agency is acting pursuant to its delegated authority to interpret the statute. And what you're calling a withdrawal is...
Yeah, excuse me, though, Mr. Street, the big difference, though, in this Title IX is the fact that you don't have to have state action to have a Title IX violation. So, and if you weren't finished answering Judge Quattlebaum's question, please continue with that. But if you could distinguish for us here, the mere fact that CDS is receiving these funds, if it's engaging federal financial assistance, according to the regulations, is extended directly or indirectly through another recipient. So why wouldn't that put both of them on the hook for violating Title IX? And well, I said, if you have more to say about the Chevron deference, please start.
Well, I can answer your question very quickly, Your Honor. There's no dispute that CDS Inc. is subject to Title IX. RBA, we've discussed extensively in our brief how it's a contractor with a recipient. It's not itself a recipient. And so it's not subject.
Be under the regulation. You look at CFR 1062.i, it talks about any entity to whom federal financial assistance is extended directly or through another recipient. Why wouldn't RBA fall into the category or through another recipient?
Well, because the Supreme Court has held that it's not just every entity that receives money from another recipient. That statutory provision has to be interpreted more narrowly to include targeted things for the precise purpose that Congress has allocated the money. So there's no question that we're subject to Title IX. The withdrawal here is more than just a withdrawal. It's not like a withdrawal of a guidance letter that like happened in the transgender situation. This is a withdrawal and a repeal of the previous regulation that authorized regulation of sex-specific dress codes. And it's not just a withdrawal. There's a reason that's given for the withdrawal, which is the Education Department's substantive interpretation of the statute to permit sex-specific dress codes.
What do you make, counsel? What do you make, counsel, of the 2017 enforcement inquiry that I think we saw in the amicus briefs, where there is an inquiry into a dress code by the Department of Education, you know, in the fairly recent history? If that was a unqualified statement that the statute didn't cover dress codes, why would they even be going into that issue?
It's very possible that that particular Department of Education official acted outside the authority of that regulation. But I do want to note one thing about that, which is that all of those inquiries upheld the sex-specific dress codes under the unequal burdens test. And so I think that's very important to note. I also think it's important to note that at footnote 12 of our brief, our second brief, we note that commentators who are friendly to the plaintiff's position that oppose sex-specific dress codes nonetheless admit that we cannot bring a Title IX claim to enforce against a sex-specific dress code because the Title IX regulation precludes that.
Let me ask you then, Mr. Street, are you saying that dress codes are wholly exempt from Title IX?
Yes, Your Honor. Dress codes are not reached by Title IX.
Let me follow up then. If CDS said that all girls had to wear bikinis so young men could appreciate the women more, are you saying that would be exempt from Title IX, that the girls would have to wear bikinis and there's nothing that could stop CDS from doing that?
Well, let me answer that in a few different ways, Your Honor. First of all, the question really gets at whether the regulation is a reasonable interpretation of the statute. And whether it's reasonable has to be judged with reference to the type of dress codes that were extant in the real world at the time that...
Counsel, I believe we've lost Judge Keenan. We might want to wait a moment until we get her back.
Okay, bear with us just a moment.
Sure.
apologies. My computer died. It was like, as I was saying to the other judges, just a nightmare scenario, and I won't even tell you what I did to get back. But we're back, and so my total apologies for interrupting things for both of you. I'm so sorry. So please, Mr. Street, proceed.
Thank you, Your Honor. I was addressing your question about the extreme hypothetical dress code, and I think that question gets at whether the Education Department's regulation is reasonable. But that question has to be addressed based on dress codes that existed in the real world at the time the Education Department promulgated that regulation. And those dress codes were very much like the dress code at CDS. They were traditional, comprehensive dress codes that imposed requirements on both sexes. Now, if at some point in the future you had this sort of insane dress code imposed, I think a lot of things would happen very quickly. First of all, the state would immediately begin enforcement proceedings under its charter, because that would violate gender discrimination protections of the Equal Protection Clause, because it clearly does impose unequal burdens on women. And probably even more to the point, you would immediately have every parent pulling their child out of that charter school and taking right along with them their state and federal funding. So if the court ever needs to reach that question, in the real world, then I think that's how it would play out. But I think, Your Honor, if I could just, of course, if there are any further questions, but otherwise I would just wrap up, seeing that my time is over. I would just say that the plaintiff's position would declare open season on traditional charter schools and their volunteer board of directors by inflicting federal fee-shifting litigation against them. And that would thwart the very flexibility and innovation that the North Carolina legislature intended when it set up regulation through a contract, not through federal Section 1983 litigation.
Okay, if you could just wind up, Mr. Street, by answering one question that kind of brings us back to where we began. How is requiring girls to wear skirts in order to promote discipline and chivalry not an impermissible sex stereotype?
Sure, Your Honor. And of course, let me preface that just by saying we don't think the court ever reaches the merits because of the state action and the Title IX regulation. But that being stipulated, the sex stereotyping evidence that the plaintiffs rely upon has several problems. First of all, it almost exclusively rests on a statement by Mr. Mitchell. But Mr. Mitchell is not the decision maker. The parents implemented this dress code. You can see that at 1756 to 57 in the record. They designed the dress code. The board of directors is the policymaker with respect to the dress code. They followed the parents' wishes, and the board of directors explained their reasons for it, which had nothing to do with any sort of sex stereotypes. And even with respect to the type of statements that the plaintiffs rely upon, they are really more in the nature of recognizing that there are physical differences between the sexes. And that's something that, of course, Justice Ginsburg told us in United States versus Virginia. They are not stereotypes that are tied, they're not statements that are tied to excluding girls from any activity. That's what the Supreme Court is concerned about. A sentiment that is, boys are like X, therefore they cannot go to nursing school. Girls are school. But here, girls are...
Yeah, the girls here couldn't play in the playground. They said they couldn't do soccer, they couldn't do cartwheels, they couldn't play on the equipment unless it was a PE day, that they were excluded from doing these things because they wore skirts. Isn't that?
Yeah, and the objective evidence that is in the record with respect to several things. First of all, that this is not just a skirts policy. There's also the option of wearing a skirt, which is a skirt, shorts attached underneath the skirt. And there's also the option of wearing leggings. And that mitigates, if not completely eliminates, a lot of the problems that they're talking about with playing on the playground and with respect to how they're distracted in class. But even more fundamentally than that, you have the expert testimony that the girls are not harmed academically by this policy. And in fact, they're exceeding males in math scores. They're exceeding their peers at traditional public schools across the board, and they're excelling in extracurricular activity. You also
but that's a correlation. That's not causation, because girls have to wear skirts. They're doing better. Aren't you suggesting that there's causation rather than simply correlation there?
No, Your Honor. We're suggesting that if this policy were harming girls in the way that the plaintiffs suggest, that they would not be outperforming boys and they would not be outperforming girls at the traditional public schools where this dress code does not exist. And you also have the evidence in the record of the headmaster that observes all of the girls on the playground. And she testifies that I've taught at public school and I've taught at CDS, and the girls are just as active at CDS. So all of these things we think are objective testimony that at the very least create a fact issue on that question.
So, Judge Keenan, can I ask one more question, please?
Yes, please.
Counsel, assume that just hypothetically that we rule against you on whether dress code, appearance codes are excluded under Title IX. Given Bostic and given Grimm, what's the standard by which we should or a court should determine whether there is a violation of Title IX? Could you articulate the standard you think applies, please?
Certainly, Your Honor. And assuming you get past the regulation, of course, then the question would be answered with the comparable burden standard that was applied by the Ninth Circuit in Jesperson and the Hayden Court under Title IX. And our position is that Bostock and Grimm do not do anything to alter that standard whatsoever. Bostock says on its face that it does not have anything to say about whether sex-specific dress codes are permissible. And the plaintiff's counsel in Bostock and its companion case both assured the court that ruling for the LGBT plaintiffs in that case would do nothing to undermine traditional sex-specific dress codes. So that unequal burden case law, which incidentally this court adopted in a slightly different context in the Bauer case, applies whenever there are comparable but different requirements on males and females. And under that test, as the Jesperson court explained it, the burden is on the plaintiffs to show that any harm or burden that is put on the girls by the dress code is outweighed by any harm or burden that is put on the boys by the dress code.
Let me just stop you and try to get one, and I know we're late and I apologize, but yeah, but I guess your answer could be neither one of them apply, but both Bostock and Grimm talk about being worse off, discrimination making one worse off. That's the quote in both of those cases. Does that language, worse off, incorporate the unequal burden test? Or unequal burden factors? I mean, we're using different language. We haven't adopted that. I'm just trying to figure out if you have a view about whether worse, what that means, because we gotta follow our precedent in the Title IX case that says worse off. And anyway, so if you could just focus on that, and I promise I won't belabor this anymore.
No, certainly, Your Honor. It says worse off than a similarly situated person of the opposite sex. So given that's the standard, and given that Bostock says it doesn't have anything to do with overruling dress codes, yes, we think that's perfectly consistent with the unequal burden standard, because there's no way to know if girls are worse off than boys unless you look at both sides of the equation and determine how much burden is being placed on boys by this dress code. It's not enough for a girl to just single out one particular aspect of the dress code that concerns her. Otherwise, every single aspect is always going to be different than something on the other side. And so I think Bostock and Grimm, obviously very consequential holdings for what they stand for, but it's also important that those are total exclusion cases. Grimm is an exclusion case. That individual was prohibited from using the bathroom that he wanted to use. These are dress code.
Excuse me, Mr. Street. Grimm was arguing the discrimination prong of Title IX. He was not excluded. He was not arguing the excluded from participation prong.
Well, fair enough, Your Honor. I think both aspects may have been at play there, but I'll certainly defer to Your Honor's reading of that. But the point is that he was worse off than an individual who had a different gender identity. And under Bostock and Grimm, the court has said that is sufficient. But the court also said at the very same time that traditional sex-specific dress codes are not invalidated outside of that particular context. And so if there's no further questions, we would ask the court to reverse on the equal protection and affirm on Title IX.
Okay, thank you. Ms. Sherwin.
Thank you, Your Honor. I'd like to touch on 3 points. First, with respect to state action, coming back to that question. An additional point that I'd like to raise about Cavanis In that case, the court was careful to note that the Arizona legislature had expressly stated that charter schools were not subject to the requirements of the Arizona Constitution. And here you have the North Carolina legislature expressly choosing to include charter schools within the ambit of the North Carolina Constitution, Section 19C1. So that's another reason that Kavanaugh is not controlling in this case. With respect to Halleck, also cited by Mr. Street, Halleck acknowledges that state action may lie where the state has outsourced its constitutional obligation, which is exactly what has happened. Finally, the state action analysis does not apply at all to Title IX, right? All that is required in Title IX is receive federal funds. And Judge Keenan, you are correct that RBA is an indirect recipient of federal funds. It is not in the same situation as the contractors that have been held not to be recipients, because in this case, the funds were earmarked for the purposes of educating students, and that is what RBA used them for directly, and it operated and managed the. I think the controlling case in this case is Grove City College versus Bell, which was essentially saying that when funds are earmarked for the purposes of education, then it does not matter that there's an intermediate. Now, turning to the Title IX analysis, the point that Mr. Freed is making, that the rescission constitutes a carve out of Title IX for draft votes, is unsupported in the law, in the purpose of Title IX, and in principles of administrative procedure law. The agency did not purport to interpret the scope of the statute, but rather was reflecting its enforcement priorities. And it could have created. Well,
Counsel, I mean, in fairness, I think we have a unique situation. But in the actual document, that what they said, they gave two reasons. They first said they interpreted the statute based on the legislative history not to include that, and then they had a secondary reason that was more akin to an enforcement issue. So, I mean, you're looking to, one of the two reasons given, and actually the second reason given. Let me just ask this, because I don't want to belay, I'm not trying to argue with you. I'd asked your colleague the question of whether he was familiar with a case like this, whether the withdrawal of a provision was given deference. And I appreciate his candor. His answer was the same as ours was. Do you have a case of a situation like this where we look to what either the Supreme Court or other persuasive courts have done with a withdrawal like this? And I know you don't have much time, so you can just give me the name of the cases and we'll look at them if there are any.
Yes, Your Honor, there is a case, and it's a Supreme Court case, State Farm case, where the court held that the rescission or change in policy, the withdrawal of a regulation, was not entitled to deference because it was not the product of reasoned decision making. And
what was that case? What was that case?
State Farm.
Thank you.
And in that case, the court held that the agency's withdrawal did not adequately take into account all of the considerations necessary, and it was not therefore the result of reasoned decision making. In this case, the same is true. The agency, if it were going to be carving out an entire area, a swath of behavior codes in public schools.
Ms. Shuren, this is Judge Rushing. I think on State Farm, it wasn't necessarily, it's not that the court disapproved of giving deference to a withdrawal, it's that there were decades and decades of reliance on the regulation at issue there. And the court said that the agency couldn't dismiss all of that reliance and change its position without more explanation than was provided. Now, I'm not saying that that's a reason we shouldn't look at State Farm at all. I don't think that necessarily answers Judge Quattlebaum's question about whether there's a case on point in the sort of withdrawal with very little said, but also very little reliance.
Well, Your Honor, this was a break from pre-existing interpretation of Title IX. And I think the point here is that if the agency were making such a break with the pre-existing interpretation, which in fact had been laid before Congress, and Congress had the opportunity to reject that interpretation had they disagreed with it and did not do so.
You're absolutely right that the agency didn't give us much to go on in what they they wrote if they were interpreting it. They didn't give us much of an interpretation. I'd like to talk about Judge Quattlebaum's question that assuming that he gave to Mr. Street, assuming that we get past this deference question and we don't defer, then what do you think should be the analysis, the way that the analysis should proceed under Title IX in light of this, no worse off standard and the case law that we have from Title VII in our circuit?
Certainly, Your Honor. The test is, were the plaintiffs here treated worse than others? Were they treated worse than others similarly situated? And that has been already articulated by this court in Grimm. And the record shows here that they were treated worse than others similarly situated. The others similarly situated are, of course, the boys who are permitted to wear pants. And the plaintiffs here have shown unique harms that they experienced as a result of being required to wear skirts to school that they themselves did not experience on the days that they were permitted to wear pants. They were, deterred from engaging in physical activity. They were distracted during class. They were subjected to teasing by their peers and monitoring and reprimands by their teachers, all of which are connected to directly the requirement that they wear skirts. And they've also shown the broader harms that flow from being subjected to sex stereotypes in the classroom, and the message that it sent to students that essentially they were worth less than the boys. Their comfort and ability to learn and play freely were less important to school administrators than that of the boys. And finally, there was no showing of harm to the boys from the parallel requirements that they wear pants.
Sorry to cut you off, and I don't want to make us go on too long, but are you saying that the analysis should be the same as the equal protection analysis, or are you recognizing a difference under Title IX? I think we've said that Title IX is not coextensive with equal protection, but how are you distinguishing the analysis between those two?
No, that's correct, Your Honor. It is a different analysis. In Title IX, what is required is a showing that the plaintiffs were treated differently than others similarly situated and that they were harmed by that treatment. And in this case, that they have shown that. Under protection, all they need to show is that there is a sex-based classification, which the skirt requirement plainly is, and that sex-based classification is not adequately justified by the government. And in this case, the charter school has not come forward with a justification that is exceedingly persuasive. What they have come forward with is a justification that is premised on the notion that women and girls are weaker and more in need of protection than boys. And that justification has been invalidated again and again by the Supreme Court and by this court.
So, Ms. Sherwin, just to follow up on that, I think you said, maybe I misheard this, but I think you said all you need to show is they are treated different and they were harmed. And maybe the harmed is incorporating my question, but I think the language is that they were treated worse off and that they experienced harm. So whereas equal protection would focus on just different treatment, it seems to be a worse off treatment. And I think there's a debate that you have with your colleague about whether worse off includes the dress code as a whole or just a certain aspect of it, that y'all have argued very well both ways. But do you agree with me that it's not just the difference, it's that you are a difference that makes you worse off and that you experienced harm?
Your Honor, in Grimm, this court said that it is treated worse than others who are similarly situated and that it caused harms. So that is the test that this court applies, and that test is adequately met here by the showing of harm that's specific to the skirt requirement and the lack of any parallel showing on the part of the defendants. And it would be the defendants' burden to come forward with any showing, not the plaintiff's burden to prove a negative, right? Lack of harm to boys. The plaintiffs don't have to prove lack of harm to boys. What they have to show is that they were harmed by the skirts requirement, and that there was parallel harm here that flowed to boys, and they have done that. So as Judge Keenan articulated correctly earlier, the fact that there are parallel harms to boys here does not negate the very real, concrete, and dignitary harms that the plaintiffs have suffered in this case, and the fact that those interfered with their educational opportunities.
Okay, thank you, Ms. Sherman. to both counsel with my computer situation. I lost track of the clock and I don't know if you got about equal time. You feel like you got about equal time? Did anybody get 14?
If I can just take one more second to sum up.
Okay, go ahead, please.
Thank you. In the relief the plaintiffs seek here is not the abolition of the uniform policy as a whole. That's why they are not tackling the uniform policy as a whole. They are not trying to take away the option for other girls to wear skirts. They merely want the choice to wear pants. So in other words, what plaintiffs are asking this court, in the words of Judge Flynn, to refuse to perpetuate the prejudices of the past. And for that reason, the court's direct entry of summary judgment to the plaintiffs on both claims against all defendants. Thank you.
Okay. Thank you both. And counsel, thank you very much for your very informative participation. You both did a great job, and we appreciate your help in putting forth all of the arguments in this case. And
thank you, Your Honor.
Thank you, Your Honor.
Thank you. We'll proceed to the next case. In the case of Friends of the Capitol Crescent Trail versus Army Corps of Engineer and others. Mr. Brown, you have 15 minutes for your opening.
Good afternoon, Your Honors, and may it please the court, David Brown for the three appellants. They asked the court to vacate the Section 404 permit issued under the Clean Water Act by the Corps of Engineers to the Maryland Transit Administration to degrade the waters and wetlands of the United States. The Corps is allowing this impact so that MTA can strengthen and widen bridges and roadways in impacted areas to accommodate rail cars along the chosen route for the Purple Line between New Carrollton and Bethesda, Maryland. In a case like this, where the project is not the type that depends upon water access, such as a marina or a dock, MTA is obliged under the Clean Water Act Section 404B1 guidelines to make a clear demonstration rebutting the presumption that there is a way to fulfill the overall project purpose without degrading the U.S. waters or wetlands. But the Corps granted the permit for a rail-based system despite MTA's own evidence that if the mode of transit were buses, there was a realistic possibility of no impact or less impact on U.S. waters because the much lighter buses could be used without altering existing bridges and roadways in the areas where the U.S. waters and wetlands would be subjected to pollution impacts due to such construction.
Mr. Brown, Judge Bredar said in his opinion, and the record does seem to bear him out, that you didn't offer specific proposals for the bus alternative routes. And that you essentially, what Judge Bredar said, if I'm paraphrasing him accurately, is that you can't come in at the last moment, say you should have done a bus alternative, but yet not have a developed plan. How do you answer that statement of Judge Bredar's in his memorandum?
Your Honor, we feel that we did adequately bring the better LEDPA, less environmentally damaging alternative to the attention of the Corps. We did that with former World Bank Group chief economist Frank Lissy, who pointed the way with his transportation project expertise, showing that upgraded bus service along the chosen route was the way to go. He and Appellant Fitzgerald did this well enough to alert the Corps of its positions and contentions sufficiently, if I may quote from the Public Citizens case, to allow the agency to give the issue meaningful consideration. We feel that no one rigorously applying the 404B1 guideline standard could fail to understand that our comments squarely raised a bus and road construction related LEDPA issue so as to enable its proper resolution with agency expertise. That in our view is as far as ordinary citizens concerned about environmental impact of a project need to go in the public comment period. They are not.
But Mr. Brown, weren't you facing an uphill battle because the previous studies had shown that the bus options were not going to be advancing the purpose of creating a more efficient transportation route? The bus options that had been examined had actually shown very slow transit times, had they not? So
Well,
didn't
Your
you
Honor,
have to show that you could do better rather than simply raise the idea of a bus option?
one has to distinguish between a bus option where there is no improvement to the roadway and guideway, and one where there is very specific improvements, such as exclusive guideways and shared use lanes, which is exactly what the BRT or bus rapid transit option provides. What MTA presented to the Corps was no information on the practicability of meeting the goal of expedited mass transit service with BRT, except as to 3 environmentally damaging BLT alternatives considered in the NEPA process. In fact, those 3 alternatives were found to be inferior to the light rail alternative that was chosen as the LEPA in reducing pollution to the U.S. waters. But that does not excuse MTA from the obligation to study the practicability of a bus rapid transit option that has either zero or minimal impact on U.S. waters and wetlands. We're not claiming that the Corps had an open-ended obligation to consider a variety of BRT configurations in light of the BRT options that were considered in the NEPA process. But given the presumption under the Section 404B1 guidelines that has to be rebutted, we feel it was incumbent upon MTA and the Corps to examine at least one plausible BRT option configuration.
And where was it, excuse me, Mr. Brown, where was the Corps going to get that? I mean, where was it going to come from? You didn't present it. So you're saying, though, even though during the NEPA process, there had been examination of bus alternatives, that the Corps had to go out and do something entirely different in the permit process when nobody had presented it with an option?
Your Honor, I just don't think under the circumstances of the obligation on the Corps to insist on a clear demonstration that there is no better, less environmentally damaging practical alternative, that it was anything like rocket science for the Corps to figure out, well, if the main problem with the
So Mr. Brown, I think I'm understanding your point to be that it's an easy enough thing to do, but you know, we're judges. Most of us aren't real good in environmental science, and we rely on what's presented to us. But are you suggesting the court should have come up with an alternative on its own, and then you know, assessed or had the parties assess that? I mean, doesn't there have to be an alternative actually brought to its attention?
That the case law basically is in agreement with you, Your Honor. Just to give you an example of why in some respects you are correct. The government relies prominently on the Hillsdale case, in which there was a railroad that wanted to build a rail truck terminal near its rail line, and the Corps looked at 7 different alternative sites, including 2 that were presented by the opposing parties, and the court said that was enough, because all of the suggestions that were brought to the attention of the Corps by the opponents were evaluated. In this case, we told the Corps in the public comment period that they could use upgraded bus service without degrading the U.S. waters. And the fact is that instead of the Corps actually considering that possibility that we raised in the public comment period, it was simply ignored in the record memo that the Corps provided. It simply concluded that the analyses that were done in the NEPA process were enough. But the NEPA process did.
Mr. Brown, you have a pretty steep hill you're climbing here, because you have to meet the arbitrary standard. And how did the Corps' analysis violate that standard? In other words, how did the Corps' analysis how can it be termed arbitrary and capricious? You're just saying the fact it didn't look at the additional bus alternatives, even though the NEPA process did look at them?
The NEPA process did not look at an alternative that avoided degrading the waters of the U.S. because the NEPA process was not sensitive to the requirements under the Clean Water Act, because the Corps was not either included as a cooperating agency or an agency that was given meaningful input in the selection of processes of choices for route selection. It was left to the last minute, and as a result, it was up to my clients in the public comment period to point out that none of these alternatives that had been presented was presented with any due sensitivity to the obligation to minimize or avoid entirely, if possible, impacts to the U.S. waters. So we feel that we adequately presented an alternative to the Corps, and that it was simply ignored. If the Corps in its record memo had said, we've looked at this possibility and find that it's impracticable because it doesn't meet the overall project purpose, that would be one thing. But to simply ignore it is, in our view, arbitrary and capricious. And the actual evidence that was in the case with regard to comparison of BRT and LRT certainly made it plausible that this particular alternative, which went unexamined from a transit expedited point of view, would have compared favorably with the BRT options that actually degraded the waterways of the United States. If you look at the if you looked at the travel times that show up in the record in the joint appendix at page 683 and 917, you would see that on an end-to-end basis, the travel times which is the critical factor in evaluating the practicability of this project, you would see that the end-to-end travel times for the high investment BRT and the actual chosen LEDPA were the same, 59 minutes. And you would also see that looking at 13 different segments along the route from New Carrollton to Bethesda, in 9 of those 13 segments, the travel time was even superior for the bus rapid transit option than it was for the light rail option. All of these made it quite obvious that what the MTA needed to do to rebut the presumption that there was a better LEDPA was to examine what those travel times would be if the BRT option avoided reconstructing roads and strengthening bridges in the relatively small proportion of this 16.2 mile rail line, by avoiding construction in those particular areas and doing all of the enhancement, the BRT enhancement, outside of that area. That is all that we're saying is flawed with this project. That obvious, what we regard as an obvious practicable alternative was not analyzed, and if found to be wanting, have a decision from the Corps that said, sorry, the LRT option that has been considered in the NEPA process is sufficient, and this particular option doesn't do any better job of lessening impact on the waters, or doesn't do any better job of lessening transportation, but that analysis simply wasn't done, and we seek vacatur so that that particular analysis can be done. We're not claiming that the NEPA analysis was flawed. We're not complaining that the Corps couldn't use the NEPA analysis. And there are a variety of other straw man arguments that in the government's briefs that are simply misstate our claims. So for all of these reasons, we feel that permits should be vacated because the MPA failed to meet its Section 404B1 guidelines obligation to clearly demonstrate that a non-damaging, or at least less environmentally damaging, bus-based alternative would not be practicable in meeting the goal of expediting mass transit service in the chosen corridor, and the Corps failed to fulfill its duty to insist on such a clear demonstration from MTA. The permit should be vacated under APA Section 7062A because the Corps failed to consider an important aspect of its statutory obligation under the CWA guidelines, resulting in a LEDPA determination that on this record at least is simply too implausible to be an application of agency expertise to which this court should defer. Thank you.
Thank you, Mr. Brown. Let's hear from Ms. Engels.
Good morning, and may it please the court. I'm Summer Ingalls here for the U.S. Army Corps of Engineers, and with me is Albert Furlow for the state of Maryland. I plan to speak for 15 minutes, and Mr. Furlow plans to speak for 5, but we both ask the court to affirm. The Corps' decision to issue Maryland a dredge and fill permit that would ultimately impact or permanently impact 0.49 acres of wetlands and 5,100 linear feet of streams was reasonable. Those impacts will be spread across a 16-mile route, and the Corps conditioned issuance of the permit on a variety of impact minimization and mitigation measures that will ultimately ensure that more wetlands will be enhanced than will be impacted once this project is complete. Plaintiffs assert essentially that the Corps should have done more, but it identifies no flaws with the analysis that the Corps completed. And given the comprehensive record before the agency, the project's minor impacts, and the regulatory framework here, the plaintiffs can identify no reason to overturn the district court's well-reasoned decision. I'd like to begin first with the appellant's assertion that the agency failed to consider alternatives that were raised with any particularity in plaintiff's comments. The only comments that mentioned specific alternatives mentioned alternatives that were considered in the Corps' analysis. So, for example, Mr. Lisi's comments mentioned the transportation systems management alternative and the low investment bus rapid transit alternative. Now, the Corps didn't dismiss any bus rapid transit alternative on the ground that it was impracticable. The agency did explain that it had some concerns about how well those alternatives would meet the project purpose, because ultimately they resulted in much longer run times from end to end than the light rail alternatives. But it ultimately decided not to select any bus rapid transit alternative as the least environmentally damaging alternative, because those alternatives had greater impacts to wetlands than did the medium investment light rail transit alternative, which
what I'm understanding here, Mr. Brown is saying really that the Corps should have done more. That what it seemed to do was bootstrap its analysis on the NEPA review, and that he provided comments that were never followed up on by the Corps, and that this is an incomplete record, that constitutes arbitrary and capricious action by the Corps. Could you address that?
Sure.
You've got the duty to do more on your own. You can't just adopt somebody else's analysis. And I think you referenced this in your brief. You do say that you are entitled to rely on the NEPA analysis, but to what extent is the Corps required to do plus? In other words, something an agency has already done plus something else, depending on what the comments are that are being received by the Corps.
Mm-hmm. I have a few answers. The first is that the Corps did not leave these comments unanswered. It collected comments from the public and submitted them to the state of Maryland, which responded or provided answers to these comments for the Corps' analysis. The Corps' request for additional information and Maryland's responses begin at page 1034 of the Joint Appendix. But more specifically, in terms of the Corps' decision to use that record that was compiled by the Federal Transit Administration, that was entirely reasonable. It's anticipated in the agency's regulations at 40 CFR 230A4 or 230.10A4 that the Corps will use a pre-existing NEPA analysis, and that in most cases that analysis will provide the information necessary to complete a well-reasoned permit analysis. And that made particular sense here because the Federal Transit Administration is the one that has the most expertise when it comes to deciding how to plan and develop these projects.
Right, but Mr. Brown's response is that doesn't, but your expertise, the expertise of the prior study was not the wetland.
Sure, of course. And there are several reasons why I think it's unfair to cast the existing NEPA analysis as one that focused specifically on transit and development of alternatives for that purpose. The record shows that even though the Corps wasn't formally designated a cooperating agency during the NEPA review, it was very much involved. Between 2003 and 2014, the Corps was involved in scoping. It was involved in on-the-ground meetings. It submitted comments that clearly were taken to heart by the Federal Transit Administration and resulted in changes in the sorts of alternatives and routing that the agency was considering. The Federal Transit Administration's NEPA analysis also includes a very detailed water resources technical report, which is in the Joint Appendix at 424 through 84. And it describes all of the wetland impacts, potential mitigation. The wetland delineations in that report were updated between 2011 and 2012, so they were very much up to date. And they identify all of the wetlands and waterways that would be affected. So by the time this permit application reached the Corps, the Federal Transit Administration had already completed a very detailed review that not only considered a variety of different project alternatives, but was also developed with an eye towards avoiding and mitigating project impacts to wetlands and waterways. And also the Corps didn't simply rubber stamp that analysis. It obtained additional information from Maryland's permit application, which has maps identifying all of the affected waterways. It worked with Maryland during preparation of that report to further reduce impacts to waterways from 0.77 acres to 0.49 acres for the alternative that was ultimately selected. And the agency requested additional analyses from Maryland regarding alternatives, selection of the least environmentally damaging alternative or practicable alternative. And as I mentioned, it requested responses from Maryland that were aimed to address the comments the agencies had received about concerns in this particular project. And one other reason why this agency's analysis was reasonable was not only the fact that it was relying on a very detailed and comprehensive record, but because the project's impacts are so small, as I said, less than half an acre of permanent impact to wetlands, it was entitled to tailor its analysis to the degree of impact. The Corps' regulations cited in my brief, 40 CFR 230.6b and 40 CFR 230.10, both explain that when the agency is completing the Section 404 analysis and deciding whether to issue a permit, the degree of analysis degree of analysis should be tailored to the degree of impact. So it's possible that if a project has significant impacts that weren't discussed in a NEPA analysis, the agency would do more to collect information to ensure that it really was permitting the least environmentally damaging practicable alternative. But here, given the analysis that the Federal Transit Administration had already completed with the Corps' assistance and the minor impacts overall over the 16-mile route, it was reasonable for the agency to decide that it didn't need to go and search for and create additional alternatives.
Now, Ms. Engels, when you're referring to the wetlands affected, you're talking about the roughly half acre, 0.49. What about the 5,000 and some linear feet of the stream? How does that play into the analysis?
Mm-hmm. They're also part of the analysis. The Corps' regulations at 230.10A3 underscore that when it's completing this sort of analysis and their impacts to special aquatic sites like wetlands, it should look first and foremost at impacts to those sites. And here the selected alternative has the fewest impacts to wetlands, which are special aquatic sites, and a little bit more impact to streams and waterways than some of the other practicable alternatives. But the Corps also required a variety of mitigation measures designed to address those impacts overall. Ultimately, coming back to the discussion we had at the beginning, it's the Corps' position that although it does bear the responsibility to ensure that it's complying with the regulations and identifying the least environmentally damaging practicable alternative, if a party is concerned about the agency's analysis and has been given an opportunity to weigh in, as the appellants were here, it should describe in detail the alternative that it would like the agency to consider. At no point in the comments during the NEPA process, during the Clean Water Act analysis, have the appellants articulated exactly what they have in mind for the Corps to consider. Now, they do mention perhaps avoiding bridge work or minimizing bridge work or minimizing road widening, but the record explains that the bridges are included in this project to avoid impacts to streams. This is a project that runs east-west, and there are stream resources running north and south, and so it's hard to avoid all those impacts altogether, and these bridges are a very important way to further mitigate or to avoid them to the extent that the agency can. And in terms of road widening and the bus rapid transit alternative, road widening is an important part of that alternative because the bus rapid transit alternatives anticipate that road widening will allow the creation of special lanes for buses, special turn lanes. And so it's hard to envision a bus rapid transit alternative that doesn't include those features. So I'm happy to answer further questions that the court might have. But
I don't believe there are any. Judge Rushing, do you have questions?
No, ma'am.
Okay, thank you.
Thank you very much. We ask the court to affirm.
And let's hear from Mr. Furla now. Mr. Furla.
Thank you, Your Honor. May it please the court. Albert Furlow here for MTA. I just want to make three relatively quick observations or points that dovetail into the government, Ms. Engel's argument. Number one, I would invite the court to look at the maps that are in the record that show where these impacts are. And that would be at the joint appendix pages 981 to 997. And what you'll see there is spread out over that 16.2 miles, there are actually 20 wetland areas that are affected. The largest wetland area affected is 0.23 acres. Okay, and that's at the far eastern end of the project. It's actually being built for, being affected for stormwater retention. The smallest wetland area that is allowed under, that is permitted in this permit is 4 thousandths of an acre, about 170 square feet. So that's, so the wetland we're not dealing with large wetland areas that are being filled in. These are very small and discrete areas that allow the project to be built.
Mr. Furlow, could I ask you the same question that I asked Ms. Engels? What are
Sure.
the 5,000 and some linear feet of the, I guess you call it creek, right?
Well, because of, yes, some of them are streams. They're smaller streams. Even for those, there are 41 different areas where there's impacts to streams. The longest stretch of any stream impact is 1,500 feet, and the shortest is 9 feet. And to the extent that these impacts occur, a large portion of those impacts occur in the context of existing streets, because for the most part, this project, the transit line itself, will run on surface streets, similar to what a bus would do, but except it's on a guideway, a designated guideway. So the stream impacts here, when you look at the record and what the analysis is, these are not overly productive streams. There are short stretches. Many of them are still are existing in culverts, and in some places they don't exist in culverts, and we're actually improving the condition of that water flow and water quality by keeping it covered, as a sense. But many of those, I mean, those are where the bridges for the projects cross these streams. So it's mostly a not parallel, but transects the streams in question. To the point of putting together an alternative that is what plaintiffs really call hybrid in their brief. When you look at what the comments are, that hybrid analogy, that hybrid alternative doesn't exist. When you look at their comments that were submitted to the Corps, they're advocating for the transportation systems management alternative, which is enhancing buses, doing some street widening, making some other traffic engineering types of changes, or at the low investment bus rapid transit alternative, which the Corps, and both of those alternatives, the Corps did consider. They're included they analyzed them in their decision memo. They looked at the possible impacts for the transportation systems management alternative. They determined that wasn't going to meet the project's purpose and need, which makes that alternative not practicable. For the low investment bus rapid transit route, they found that actually had more of a wetland impact than the selected alternative. And by quite a large, well, we're dealing with small impacts to begin with, but the bus rapid transit wetlands impact was twice the amount of the selected and permitted alternative here. The third point I'd like to make is, to the extent that Your Honor, Judge Keenan, you were talking with Mr. Brown about the Corps having expertise. I would point this court to the Seventh Circuit decision in the Hoosier Environmental Council versus Corps case, which addressed this question head on. And in fact, in a decision written by Judge Posner, he basically said that what the plaintiffs were asking for, and there they were also asking for, you should have looked at different alternatives or a hybrid alternative. What Judge Posner said is that what the plaintiffs are asking for is for the wetlands tail to be wagging the transportation dog. And he went on to say that in order to do this, the Corps would have to bulk up on its staff with experts on highway design, construction, and transportation. That's not what the Corps does. The Corps is not a transportation agency. It reasonably relied upon the FTA's analysis for transportation needs and issued a permit in accordance with its own regulations. So we would ask that the district court be affirmed. I see I'm out of time here.
Okay, thank you. And Mr. Brown, your response.
Thank you, Your Honor. Counsel said that the Corps did not leave the comments unanswered. In fact, what happened was, and you can see the letter of invitation at pages 1102 to 04 of the joint appendix, the Corps asked MTA in a very general way to respond to the public comments. It did not specifically ask MTA why our comments should not give rise to any doubt that there was no available LEDPA superior to the one favored by MTA. And MTA did respond, but those responses, although they're in the record, are not mentioned or relied upon by the Corps in the record memo supporting the permit. It would be nothing more than improper judicial guesswork to ponder whether and to what extent those responses played any role in the decision. Counsel also said that the Corps was very much involved in the route selection process, but you will see on pages 15 to 19 of our reply brief that we looked at everything in the record that shows the Corps' involvement in the route selection process early on, and found that their participation was almost inconsequential, to the point that they made one suggestion in one specific location and nothing else. Council also refers to mitigation efforts made with regard to the chosen alternative. Those mitigation efforts are legally irrelevant to the adequacy of the LEDPA determination. Council also argues that the project impacts are so small that it justifies no further examination of the alternatives. In fact, you will find nothing in the record memo to suggest that the Corps felt that it was in any way relaxing its effort to look at project alternatives by the conclusion that the environmental impacts were small, and we don't agree with that in any way. Council also said that you really would be difficult to conceive of BRT without the guideway features that we are advocating. But our point is not that the BRT process should be absent those features. Our point is that those features should be employed outside of the areas where there would be environmental impact. We believe that a very strong case could be made that there would be so few areas where there would have to be an accommodation along this 16.2 mile route to deal with environmental concerns, that the efficacy and of expedited mass transit service could probably be just as well featured with a BRT option that was sensitive to avoiding construction in those sensitive areas, and did everything possible for enhanced BRT outside of those areas. That is not something that it would have been beyond the expertise of the MTA to present in order to, if it felt it was impractical or infeasible, by way of response to our public comments, because our public comments quite clearly raised the problem in sufficient detail to put the agency on notice. And it certainly is not the obligation of individuals in the community who are simply concerned about environmental impacts to design and present at the very beginning of the review process in the public comment period, and it's their only opportunity to say anything, some kind of complete engineered designed alternative. We put the government on notice that there was a better way to do this, and they simply ignored it and let the project go through on the blithe assumption that everything that needed to be considered was considered in the NEPA process that pointedly excluded input and cooperation from the Corps on the critical CWA permit requirements, which in contrast to the NEPA requirements, imposed some real substantive requirements that have to be met. So for all those reasons, Your Honors, we feel that the permit should be vacated and sent back to the drawing board for a much better explanation. Perhaps the kind of explanation that you heard from Mr. Furlow might well justify the same conclusion again, but it's not in the record. It's not in the decision. It's not in the rationale of the agency. What you have instead here in this court are counsel's post hoc rationalizations, not the reasons and arguments advanced by the Corps in its record memo. Thank you, Your Honor.
Okay, thank you very much, Mr. Brown, Mr. Furlow, Ms. Engels. We appreciate your argument and all of your work that you've done in presenting the case to the court. At this point, I would ask our judges if we could take a short break so that I can look in to see why my computer is flickering. Would that be okay if we take a 10-minute break, Judge Quattlebaum, Judge Rushing?
Sure.
Okay.
Thank you.
Very much. Court will be 10
The court will take a brief recess before hearing the next case.
I'll move the attorneys into the waiting room.
Okay, thank you. right, good afternoon, Council. We're pleased to be proceeding now in the case of Justin Fairfax versus CBS Corporation. Mr. Breckenridge, are you ready to proceed?
I am, Your Honor.
All right, thank you. If you would please do so.
Good afternoon, and may it please the court. I'm Tillman Breckenridge on behalf of Justin Fairfax. CBS did not just report the false allegations of rape and sexual assault against Justin Fairfax. It heavily promoted direct interviews, resurrecting the false allegations 2 months after they were made, and then doubled down by endorsing them, saying, among other things, it, quote, feels like she was forced, and, quote, all these years later, that pain has stuck with them. As much as CBS wants to make this a grand assault on journalism, CBS is the only defendant here, and its unique behaviors go well beyond establishing a plausible claim that it published false accusations of sexual assault by Mr. Fairfax and endorsed them with actual malice. A reasonable juror certainly could so find on both defamatory material and actual malice. As to defamatory material, the allegations themselves are defamatory per se. And independently, there is no question that a reasonable juror could conclude that the additional statements endorsed the false allegations. And then as to actual malice, the complaint provides no fewer than 12 indicia of actual malice, in addition to the slanted comments the co-hosts made at the end of the 2 broadcasts. Regarding the eyewitness, CBS even conceded at the hearing below that the eyewitness by itself would be sufficient indication of actual malice to meet the plausibility standard if Fairfax had identified him as such. Given Fairfax's spokesperson walked CBS right up to that door with Damian Blue and Joe Richburg, the 11 other indicia of actual malice have to be enough to meet the pleading burden. And I think that's important to keep in mind. We're at the pleading stage.
Mr. Breckenridge, are you saying that the CBS reporter lied about being unable to reach the 4 individuals that Mr. Fairfax's spokesperson suggested that he talked to?
Well, no, 2 things on that, Your Honor. First of all, I'm not saying that he lied, but there are 2 things on that. First of all, there's just nothing in the record saying whether he lied or whether he told the truth. And second, that was on February 8th. So on February 8th, Fairfax's spokesperson gave him a list of 4 names. And then on February 8th, he texted back saying, oh, one of these people is a CBS reporter. And then further adding later on, they haven't returned our calls. Please urge them to get in touch. Between February 8th and April 1st, there are almost 2 months where we have absolutely no idea how much effort was taken to get in touch with these folks. But we know that whatever effort was taken, they did not actually learn the valuable information from them as far as the fact of the eyewitness. And one of those people was one of their own lawyers. So given that, given that timeline where there are these 2 months, I think that's a really important factor. Judge Rushing?
Yes. We're here on a motion to dismiss. So your point that there's nothing in the record about, what they knew or didn't know seems to maybe cut against you, don't you think? You can't know things that you're not privy to about what happened or what didn't happen, but you have to plead actual malice plausibly, which means you have to plead that there was knowledge of falsity or that they were reckless and disregarding falsity. So what do you have on that point? Not just that, there's speculation about what might have happened, but what has been pleaded that they actually knew or were reckless that these allegations were false?
Well, Your Honor, there's a list. There's a pretty long list. But first of all, there's the fact that they knew. They had Joe Richburg, a CBS lawyer who counsels them on defamation. They knew that he had information and they did not obtain it, or if they did obtain it, they withheld it. It's got to be one of those 2. Number 2, they knew that they had these questions that Fairfax's spokesperson suggested that they ask that listed things like, did you see anyone when you walked in the room? Did you see anyone when you leave? They knew that neither of the accusers was willing to participate in criminal investigations, even though at least one, and I believe both of them, were still within the statute of limitations. They knew that they knew about the issues with Duke and the fact of the assertion by Meredith Watson that she had been raped at Duke, and that Duke had Duke had disagreed, or at least stated that it could not find anything in its records to suggest that she had claimed that she had been raped by someone else at Duke. They knew that there were, they knew that that despite CBS, despite having easy access to Fairfax's spokesperson, they knew that they weren't making any attempt to let her know that they were doing interviews. They knew that
what does that have to do with knowledge of falsity?
Well, I think it's evidence of purposeful avoidance of truth. Insofar as, you know, they have people who know things. They've gotten this list of, and they don't even try and get information from them. So, for instance, they had got this list of 4 people from Fairfax's spokesperson, and then 2 months later, in all that time, they never asked her anything about them. And they, you know, in the brief, CBS asserts that somehow it was Fairfax's responsibility to explain exactly what these people's value was to determining the falsity of the allegations. But then in 2 months, they never actually asked that question. So I think that that's
Ms. Breckenridge, then are you saying that that's reckless disregard of the truth? Because in order to surmount the actual malice standard, you've got to show reckless disregard. There has to be reasons to think that the CBS had to have reasons to believe that the information provided by Wilson and Tyson was false, didn't they? And where do you have that in your allegations, that CBS had a reason to doubt the veracity of these 2 women, or that the fact that they hadn't talked to these other witnesses created a doubt as to the veracity of the 2 women?
Well, Your Honor, I would disagree with the premise that they have to, that there has to be some proof that they, that their purpose, that some proof beyond their purposeful avoidance of the truth. There are statements that a failure to investigate alone is not enough to prove actual malice, unless there is objective reason to doubt the accusers. But that doesn't mean that that evidence is irrelevant, and it certainly doesn't mean that we ignore all the other indicia of actual malice. We have to take all the indicia of actual malice together to determine whether or not there is circumstantial evidence, because of course we don't have direct evidence at this point, an admission by CBS. We haven't even had any discovery to perhaps get that. But the question is whether we've plausibly pled enough circumstantial evidence to establish that it's at least plausible that they engaged in a purposeful avoidance of the truth. And given that, all of these indicia of actual malice, all of these things indicate a purposeful avoidance of the truth. Just like in Palin, they indicate that CBS had an agenda, given its motive of having had the issues with Les Moonves and Charlie Rose happen, and the fact that they needed to show an identity with the Me Too movement. And given that motivation, and then given the fact that this happened and these allegations happened and gave them the opportunity to push an agenda showing that they are on the side of the Me Too movement, and then putting that together with all of the other indicia that they purposefully avoided the truth, I think it really just it makes an overwhelming case of at least plausibly pleading actual malice.
And Mr. Breckenridge, you know, I agree with you that the comments that these talk show or morning news made, the commentary is really kind of unsettling. I agree with you on that, but you know, the law says we've got to look at everything. And during the presentations, there was a constant reminder that Mr. Fairfax denies this. You know, if you look at the overall context, and this is what Judge Trenga, I think, was saying, when you look at the overall presentation, it isn't a totally one-sided presentation. It presents the information detrimental about Mr. Fairfax, but also says categorically he denied it. So when you look at the whole picture, you're saying still that their failure to pursue the truth with notwithstanding the whole context that we have to look at gets you over the bar of actual malice. Is that right?
Yes, Your Honor, because I think that, you know, the reasonable inference of whether or not the inference of whether or not they really did present both sides in a fair way is really a jury question. Once you get past the issue of whether or not whether a person is reasonably capable of determining that the purportedly two-sided presentation was actually two-sided. If looking at that presentation, I don't find it two-sided at all. I find it very one-sided. They give these long segments of interview, and then they quickly give Mr. Fairfax's denial and immediately follow that up with their commentary that undermines Mr. Fairfax's denial. That I think a juror could be reasonably capable of determining that's defamatory, and that going into the quick denial and providing the denial information is a mere fig leaf.
So counsel, Mr. Breckenridge, this is Judge Quattlebaum. I following up a little bit on Judge Keenan. I can see certainly an isolated comment, and you're probably right there. Timing wise, it's disproportionate, but even at a 12B6 stage, I think we have to look at whether a reasonable juror could, if accepted as truth, consider that as taking one side. It seems like if this takes one side, we got defamatory statements, the defamation right and left all over the news these days, and maybe we do. Maybe that's the point. But I mean, if you're right, we have sweeping defamation and actual malice all over the place, don't we?
No, not at all, Your Honor. First of all, I would say that the defamatory material here, this isn't a case against the other major media outlets who reported this. This is a case against CBS. Now, you noted that there might be one statement that's a stray statement. This isn't a case of one stray statement. This is a case of 8 statements that CBS calls off-the-cuff statements. But there are 8 of them after these interviews, and they are a minimum of 8. It's more like 9 or 10, just depending on how you parse it. And all of them are in favor of the accusers. So this is not a case. And on top of that, you have to, under Virginia law, you have to establish not only that there's defamation, but you also have to establish the mens rea. So yes, there is defamatory material published all the time by news media outlets. That doesn't mean that there's an actual case for defamation, because you have to meet the mens rea requirement under Virginia law. Now, mind you, in this case, the mens rea requirement under Virginia law is irrelevant because it is negligence, and we have to meet the actual malice requirement anyway. But in either event, that was one thing that Judge Trenga, I think, got pretty wrong, was that Judge Trenga brought issues of actual malice and then brought them into defamation, into whether they said anything defamatory. But defamatory material was definitely published here by CBS. CBS acknowledges the common law rule that is defamatory material at page 30 of its brief. And then it asked this court to create new Virginia policy, which I don't think is the role of the court, and create new rules whereby it's not defamatory material. But Virginia already has covered that. Virginia already has made it not an option to make all defamatory material create liability by adding the mens rea requirement. And so, given that, this case really, I think, hinges on whether or not actual malice is plausibly pled. And given that there are 12 indicia of actual malice listed in more than that in the complaint, 12 listed in the briefs, you're taking them all together, just like in Palin, Fairfax has met the bar for plausibly pleading actual malice, and of course, for plausibly pleading the publication of defamatory material. Unless the court has any further questions, I'll reserve the remainder of my time for rebuttal.
Okay, thank you. Let's hear from Mr. Brown.
Thank you, Your Honor. Jay Brown for the defendant, CBS Corporation, CBS Broadcasting Incorporated. As the discussion so far suggests, the district court had 2 independent grounds for granting the motion to dismiss. We believe it should be affirmed on both counts. But let me begin with the one that presents a pure question of law, not an issue of pleading. And I'd like to unpack the unnecessary complications that are imposed on that question. It is firmly established in precedent both of this court and of the Virginia Supreme Court that it is a threshold question of law for the court at the pleading stage. In fact, the Virginia Supreme Court in the Webb case has referred to it as an essential threshold gatekeeping function to determine whether the publication as a whole, giving the ordinary meaning to those words, giving words the meaning that they appear to have been intended to convey, in fact, is reasonably capable, that is, whether the archetypal reasonable person would understand the whole publication to convey the defamatory meaning alleged by the plaintiff. The Virginia Citizens Defense League versus Currick case, the court's decision in 2018, makes it very clear that that threshold question is answered, presented at the stage, and only if the archetypal reasonable viewer interprets the statement with that defamatory meaning, does there then proceed to the jury the question of whether viewers of the program, actual viewers, in fact interpret it in that way.
I'm sorry, I don't have a question. I'm just having difficulty hearing you. I don't know if you can step closer and it'd be better. I apologize. We're all doing our best, so I'm not being critical here. But if maybe that'll help getting closer.
Certainly, but I do apologize, Your Honor. It is not usually my problem at being too quiet. And is that better?
No, that's a little better. I think something's kind of goes out, but we'll do our best. Thank you.
My apologies, and let me know if the court would prefer that I dial in instead. But as I was saying, in the Currick case, this court's 2018 case, and in the Webb case, both of which are cited in the papers, Webb being the Virginia Supreme Court opinion, the court clearly held that this is a question of law, the question of whether the publication is capable of the alleged defamatory meaning. In the Webb case, the Virginia Supreme Court reversed a verdict and said that the trial court should have dismissed at the pleading stage, at the demurrer stage in state court, precisely because the statement there was not reasonably capable of the defamatory meaning alleged. And the facts are quite close here, Your Honor, between Webb and this case. In the Webb case, the plaintiff complained that the newspaper article conveyed the impression that the principal, assistant principal, had arranged special treatment for his child. But as the Virginia Supreme Court pointed out, that same article included an express denial by school officials that there had been any special treatment or interference. And the Virginia Supreme Court had that a reasonable reader who is charged with reading the entire publication and construing it in the ordinary sense would not attribute to the newspaper the assertion that the plaintiff assistant principal had in fact interfered in the disciplinary process there. And those facts, Your Honor, are closely analogous to the facts in which, although CBS presented the two women explaining their allegations, it also repeated fully, both on screen in text and through anchor Gail King reading aloud, Fairfax denials of those same allegations, and referred the audience members to the website where Mr. Fairfax's written statement was printed in full.
Mr. Brown?
Yes.
Judge Keenan, it did make me uncomfortable when I listened to this on how these news people were saying feels like she was forced. I mean, and maybe you can say that's a statement of their opinion, but it really left me with an uncomfortable feeling how they seem to showcase this, kind of a touchy-feely presentation based on what they were thinking rather than what the news story was. How do you counter that? I mean, what I'm trying to figure out is, should this have gone to a jury? really pretty atypical for people to talk about whether a victim is, so-called victim is forced.
But Your Honor,
really kind of outside the typical presentation, isn't it?
Well, no, Your Honor, not in the facts of this case. Remember, it is important to remember that in this case, this is not a situation in which one, or in this case, two women claim they were sexually assaulted, and the alleged perpetrator's response was, I've never ever seen that woman before. I've never been in the same room with that woman before. In this case, Mr. Fairfax admits, and both of the women say, that the encounters began as consensual sexual encounters, which in the women's view, at some point became non-consensual, and Mr. Fairfax refused to acknowledge that. And in that context, Your Honor, I think it's perfectly reasonable to read Ms. O'Donnell's comment. You're referring to the DVD Exhibit 3. The transcript is Exhibit 4 at docket 17.5. And the full quote coming before that is one of the anchors saying, you could see where she got very emotional and went to that dark place. And Ms. O'Donnell says, yeah, feels like she was forced. And a reasonable construction of that is that Ms. O'Donnell was simply repeating the statement by Ms. Tyson that she felt forced, that the sex at one point became non-consensual. And Ms. King in that same exchange referred to what Ms. Tyson, quote, what she says happened. And so I think in fairness, Your Honor, in the exchange, the comments which are in direct response and follow a tear-filled encounter explanation of what that woman contends are comments on and understood as sympathetic reactions to the emotion being displayed. That's true of the second broadcast as well, in which the anchors talk about how the pain has stuck with them and how they felt in that moment. But nowhere, Your Honor, do any of the anchors in fact endorse the notion that the encounter was non-consensual. The anchors do not assert that Mr. Fairfax in fact raped or sodomized either woman. And again, Your Honor, having seen the DVD, as I understand you have, you'll recall that across the bottom of the screen while the women are speaking, they are referred to as accusers. It's a graphic that says they are accusers. Mr. Fairfax's statement, you will have seen, was the words were quoted in writing on the screen, read by the anchor, and in the Couric and in the web cases, both this court and the Virginia Supreme Court said you have to look at all of the elements of the program. You can't isolate the particular segment or particular sentence that the plaintiff complains about. And in both of those cases, because of the material adjacent, and in the web case on the closely analogous fact that what was adjacent was a denial by the school that there had been any favoritism, both this court and the Virginia Supreme Court concluded that the archetypal reader would not interpret those as an endorsement by the publisher, in this case the broadcaster, that the sexual attacks in fact took place, or put more precisely, did not endorse the proposition that these encounters became non-consensual and that Mr. Fairfax was acknowledged. And Your Honor, it is crucially, I beg the court's pardon, my screen just went blank. There you are, you're back. In this regard, Your Honor, the suggestion that that automatically becomes a jury question because certain people, Mr. Breckenridge said he won't read it that way, simply isn't legally relevant here. In the web case itself, several people at trial had testified that they read the statement at issue in web in the way that the plaintiff claimed it should be read. And the Virginia Supreme Court nonetheless reversed the verdict for the plaintiff and held that the claim should have been dismissed at the pleading stage because the presence of that denial, reporting of the denial in immediate proximity to the allegedly defamatory statement, rendered it unreasonable as a matter of law for a viewer to interpret it that way. And
Mr. Brown, I mean, I'm not trying to tell you how to do your argument, but I appreciate those comments. I'd like to hear from you on actual malice, and I'd hate for the clock to run too far. If you would please address that, make sure you give yourself enough time to address that issue. That's something I want to hear from you on.
By all means, Your Honor, I appreciate that and want to be heard on that as well. And I would just conclude the defamatory meaning argument by the observation that the district court did exactly what the binding case law required it to do, and in our view correctly held that reasonable viewers would not conclude that CBS itself was endorsing the conclusion that Mr. Fairfax raped or sodomized a woman. And actual malice presents an entirely separate it's the state of mind of persons at CBS responsible for this broadcast. And that's an important point. Whether those individuals responsible for the broadcast in fact either knew that the women's allegations were false or went ahead and broadcast the interviews in question while seriously doubting whether they were true. And because we're at the pleading stage on this issue, the Iqbal-Twombly pleading standard applies, and the question is whether the facts, not conclusory allegations, but whether the facts pleaded by the plaintiff lead to the reasonable inference, and remembering that the plaintiff's burden of proof on this point is clear and convincing evidence, the reasonable inference in that light that CBS in fact doubted the truth of the women's stories. That approach and that standard is set out in the Royber case, which was this court's en banc announcement on this issue. And here, Your Honor, the Horn case is controlled both on the facts and the law. That's Horn versus WTER. Judge Keenan was a member of the panel in that 2018 case. There, the contention, like here, was that the failure to investigate, in that case, an anonymous email that disputed the story, was the evidence of actual malice because the reporter did not undertake to further investigate the information provided in that anonymous tip. And this court held, following its own prior precedent and precedent of other courts, held that there is no duty to investigate, to follow up on every single conceivable lead where there is no obvious reason to doubt the primary sources or the other sources of information in this regard. As this court put it in the Horn opinion, quote, failure to investigate every potential lead cannot amount to reckless conduct. And the court in that regard was referring back to an earlier decision, Ryan versus Brooks, a 1980 decision of this court, which made exactly the same point. And so the threshold question that Mr. Fairfax has to overcome in his pleading on actual malice is to establish that CBS had obvious reason to doubt the two women's stories. And this he cannot do. First of all, he argues broadly that CBS was on notice that the women suffered from credibility. In particular, he focuses on Miss Watson and the Washington Post's initial story on this, in which the Post printed that it had been unable to corroborate her story. Now, we reject the notion that the journalists at CBS are charged with knowledge of anything ever published by anyone. But the problem is that even if you accepted plaintiff's legal theory on this, that they should have known the Washington Post said it was uncorroborated. The problem is that a few days later, on February 8th, the Post published the articles in the record, in the joint appendix, that they had found two sources to corroborate Miss Watson's story. A classmate to whose room Miss Watson went, as the Post reports it, and we're not offering the article for the truth of the matters reported, but in response to simply to Mr. Fairfax's contention that Washington Post reporting should have put CBS on notice that the woman had credibility issues. Because the very next news report published by the Washington Post said two sources, both named in the article, corroborated the story. One saying that immediately following the rape, Miss Watson went to this woman's room and told her that she had just been raped by Mr. Fairfax at the time. And then the Post also reports that it was shown an email from 2016, in which again a named source quoted in the Post article says that when I sent a fundraising solicitation for Justin Fairfax to Ms. Watson, he responded by email. They showed the email in which Ms. Watson says, "I was raped by Justin, please take me off the fundraising for him." So the premise that Mr. Fairfax has adequately alleged that CBS was on notice of obvious reasons to doubt Ms. Watson's story is absolutely belied by his own theory and by what's in the record. And so in fairness, Mr. Fairfax does point to a couple of other things. He points to what we referred to as the CBS attorney and the purported knowledge held by that attorney that Mr. Fairfax argues would have been relevant to a decision whether to proceed with the story. The problem, there are several problems with that theory. First of all, Mr. Fairfax fails entirely to allege any actual link between that attorney and the preparation of these broadcasts. And as has been the law of the land since New York Times versus Sullivan, that is an element of proving actual malice, is to tie that state of mind to the persons actually responsible for the broadcast. And all Mr. Fairfax alleges is that lawyer somehow had some responsibility for defamation at CBS Corporation, not at CBS Broadcasting, broadcast the actual report. That alone eliminates that issue as a plausible basis on which actual malice could be stated. But as Mr. Breckenridge conceded, the plaintiff pleads at paragraph 138 of the amended complaint that they don't know whether or not anyone actually spoke to the CBS attorney, although they can say for certain is that no quotations attributed to him were included in the broadcast. That Mr. Fairfax deliberately, and he has proudly announced in his public statements, which are part of the record, and acknowledges in his pleadings, his counsel in the district court conceded that he deliberately withheld and chose not to disclose to CBS at any point until July, after this litigation was filed, why it was worth talking to the CBS lawyer, or why it was worth talking to other people on the list of sources. That is because a man named Damien Blue was, according to Mr. Fairfax, present in the room. And according to Mr. Fairfax, Mr. Blue told the CBS lawyer that as he watched the sex act, he felt it was consensual. Insofar as the CBS lawyer had that conversation, that's of course hearsay. And in addition, Mr. Blue may face potential liability for witnessing if it turned out the woman was correct that a crime was committed there. So CBS's decision not to include that in the broadcast itself cannot be evidence of actual malice. I see my time is up, Your Honor, and unless there are questions, I'm happy to rest it back.
All right, thank you. Mr. Breckenridge again.
Thank you, Your Honor. I'd like to address a few things mentioned by CBS just now. In particular, I wanted to talk a little bit about Horn and then a little bit about Webb. CBS's counsel, my friend on the other side, talked about Horn, and Horn only stands for the proposition that alleging a failure to investigate is not enough to prove actual malice. But again, we have so many other indicia of actual malice. And the eyewitness issue actually comes up pretty big in this, because I believe my friend on the other side misspoke when he said that Mr. Fairfax identified the eyewitness in July, and after this litigation was filed. This litigation had not been filed. I believe it was filed in November of 2019. And the CBS is the only major media outlet that to this day still refuses to update its reporting. Another indication of actual malice. So here we have all these indicia of actual malice, and unlike Horn and more like Palin, and actually beyond the indicia of actual malice found in Palin. Also, as to Webb is actually a great example, and the comparison between Webb and other cases is a really great way to kind of acknowledge this reasonably capable standard, reasonably capable of being interpreted a certain way, which is basically the normal standard for summary judgment. My friend on the other side uses phrases like the archetypal reasonable viewer would not view it this way, but that's different from what's reasonably capable. And so the court's gatekeeping function, to the extent that it has one under federal law beyond basic plausibility, which would be inappropriate in any event, but regardless, the basic plausibility standard is whether or not a reasonable viewer is capable of viewing things this way. So while my friend on the other side likes to say things like these were just the statements by the co-hosts were just sympathetic reactions to the emotions being displayed, I don't find that to be a plausible explanation of what they were saying when they say feels like it was forced. And then they talk about feelings that have existed for decades, which assumes that they actually had these experiences decades ago necessarily. But at the very least, even if it is just sympathetic reactions to emotions being displayed in some reasonable viewer's mind potentially, that does not exclude the plausible interpretation, the plausible inference that they were actually endorsing the statements of these women, of the accusers. And so you go to Webb, and if you compare Webb, in Webb, the court the court ruled that it wasn't reasonably capable of being interpreted against the plaintiff because the article made it sound like school administrators, not the plaintiff, had their thumb on the scale. Here, this is all about Mr. Fairfax. I see my time is up, and so I urge you to vacate the decision of the district court.
Okay, thank you. Now, the parties have not argued the cross appeal here. Mr. Brown, did you want to ask the court for a couple minutes in order to make a very brief argument on that?
No, Your Honor, we're content to rest on the papers. That presents a pure legal question, the appropriate standard, and I think it's sufficiently set out in the papers. I would like to correct, as my colleague pointed out, when I said that the complaint was filed in July of 2019, I meant the public announcement of Mr. Blue's identity was made in 2019. My underlying point remains the same.
Okay, well, thank you both. Let me see, does Judge Quattlebaum or Judge Rushing, do either judge have any more questions?
No, thank you.
I do not. Thank you.
Okay, well, counsel, the panel would like to thank you for your careful attention to this case and for your argument, which has been very helpful. And at this time, I'll ask the clerk to recess court.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.
Judges, I will move you to the robing room now.